Again, Manning, thank you for joining me this afternoon. I had a lot of cases recently where clients have come that came from somewhere else, and so I've had a lot of cases recently where we've been doing estate planning or estate administration for someone who has real property in multiple states. So Texas typically, while they're a resident here, they have it some other state or maybe even out of the country has happened recently. And so I wanted to talk about a couple of things to consider about how to deal with that, and both in the estate planning way and how it's going to affect you in the estate administration way. So, like I said, a lot of people seem to have this. It's a very mobile society, so it's a very common issue. So start with this as point one. If you own real estate in multiple states, you will probably, depends on the states, have to do two probates. You do the probate here, again, assuming you're a Texas person, you're a Texas resident, you probably own the residence here. And then to gain control of real property in another state, you essentially need that state's permission. And depending on that state's law, you're either going to do it by probate in that state, an ancillary probate they call it, or some more abbreviated process, excuse me, where you can basically take the quality of the probate here and just docket it there in that state. Some states do let you do that. But what you can imagine is it makes for a lot of extra hassle. So something we talk about a lot is probate avoidance and being able to do things quicker and more streamlined in the state administration, such as by doing it through trusts. And if you own real property in multiple states, you are a excellent candidate for this kind of thinking, because one probate is maybe not that bad in Texas, for example, but we don't know what the other probate would be like and what you're going to have to go through to do it. So we want to take all of that complexity out, and ideally what you would do is you would avoid both by having a trust. Okay. Now, I will say that there is sort of a second option with regards to how to deal with out-of-state real estate, no matter what kind of estate planning you do here, is that some states, like in Texas, we do have transfer on death deeds. We have ways of conveying land to your beneficiaries that do not necessarily require the probate process. Now, different states have that, some don't. I found generally some states have it's been a newer trend to allow that kind of deeding, to create deeds like that. And it tends to be more to the western, maybe in the southwestern part of the country, as opposed to the northeast where I'm originally from. But it is a very good option when you're not going to use a trust at all. If you did, you would just incorporate it into the trust. But if you don't use a trust and you want to deal with out-of-state probate and avoid out-of-state probate, a good solution might be doing some sort of a transfer on death deed for the land there. Now, one point I do want to make is I often used to get this kind of a question, which is, why can't I just put my kids on the title now or something like that? I don't think people do that as often as they used to, but an attorney a long time ago told me that was Western Pennsylvania estate planning for all you Pittsburgh watchers. And he wasn't wrong, as far as that's how a lot of people just did it. Now, I won't go through all of it right now. You can see several other Kevin's Corner touching on this, but even that's not really a great idea. Now, one, because if you're adding kids to your title, you're taking all of the problems that come with them, their creditors, their assorted issues. Maybe that's an issue, maybe it's not. Two, you are making a gift to them. So depending on how you're doing it, and if you're doing it to avoid probate, this is probably how you're doing it, you're setting it up so that they either own it or own all of it upon your passing. That does mean that that's not going to go to your other kids, or it's not going to go to your other beneficiaries. I know a lot of people say they'll do the right thing, they'll share something, but it's an illiquid asset. They're not going to be able to do that. So a lot of times it disrupts the rest of the estate plan to just add on a kid to your deed. And then finally, just as a thought on that, is it has tax ramifications. No, I'm sorry, I got two more points. It has tax ramifications, which is if you just give away property, and let's say after you pass away, then they sell it because they don't need it anymore, you're not living there. They're going to pay capital gains on the growth from whatever your cost basis is to what its value is if you gave it to them during your lifetime. Okay? They're going to have a tax hit there. If you own it at the time of your death, if it's essentially in your estate for estate tax purposes, we'll say, then they will not have any gain. The cost basis, what you acquired it at, is equal to what it's worth then. Okay? So there's zero gain. So there's no tax now. There might be other state taxes that you have to deal with. Again, Pennsylvania has inheritance tax, so there is a tax there that could be applicable. But a lot of times when people do that, they end up avoiding a probate and maybe avoiding some of the costs or even maybe inheritance tax, but then end up creating for themselves a much bigger capital gains tax that wipes out the benefit they ever would have gotten, especially things you know you're going to sell. So, with all of that having been said, what is really probably the best way to handle it? If you've ever watched my show before, you probably know what I'm going to say. You should consider the use of a trust. If you have land in multiple states, that takes so much of the complexity out of this. You can have, depending on that state law, either the trust own that land or have it transferred to the trust at your death. So you're not probating in 2 states, you're not even probating in 1. The trustee already has control of the asset and then can just start the trust administration as you designed. That takes all of it out. Doing it that way, it is not a transfer to a third party, so you still get the step up in basis. And the point I meant to make before is if you just add a person onto your name or to your title, and it's later in life, and you start to have long-term care needs, and you end up using Medicaid, a gift, adding person to the title, is a gift to them. It is a transfer without value, without adequate value in return. And there are some exceptions to this, I should say, but if it's within 5 years of you needing Medicaid, it's probably going to make you ineligible for Medicaid, at least up to a certain value of the house. So avoiding all of that complexity makes having something in a trust or conveyed to the trust upon death through a transfer on death deed far more attractive. Now, I've alluded to it a couple of times. The specific way of handling it for you really depends upon the states where the land is, because there are different options in different places. But for most people that we find, especially in Texas, the best option really is, in most cases, to have trust here, let it own or receive upon death, as we can do that in Texas, the land you have here, and do the same thing with things that are in other states so that you avoid probate in all of those places, and subject to those state taxes, get the best tax consequence for everyone and maximize what you're leaving to your beneficiaries. So if you have real estate in multiple states, even if you're not a Texas resident, you just have it in multiple states, you want to think about doing this to avoid all of those challenges that I just described. By all means, call us, or you can look up on our website, and for all the other information we have on our blogs and our newsletter, our website's galliganmanning.com, and you can see a lot of good ideas there about where to get started and what else to include in your estate plan. So with that, thank you all very, very much, and I look forward again to seeing you again next week on Kevin's Corner.